Attorneys for Atlanta rapper Young Thug will be in court today. It'll be the final hearing in a civil case. Several items, including jewelry and cars, were seized from the rapper's home. This happened before the criminal trial involving the rapper. The state argues the property is from criminal activity, so Young Thug should not get it back.
It is not his duty to assist the state in depriving him of his property.
Hi everybody, it's me, AV. Welcome back to my YouTube channel where we talk about all things law, true crime, and a little bit of debauchery. Listen, Young Thug just had a big win in court. I cannot wait to show it to you guys. We know that over the past few years, this guy has really had a hard time with the legal justice system in Atlanta and his battle with one Fonnie Willis. Well, today, Thugger finally has a win, and that win comes at the helm of the GOAT, Brian Steele, back in court after he just helped Diddy with his RICO charges. Let's check it out, everybody, and get on into it.
Required to reset the trial date or move for continuance before the second-day period expired on June 23. The result of a failure to conduct the hearing within 60 days or to obtain a good cause continuance is a dismissal of the state's complaint.
There he is.
The state's arguing here. I'm reading again. The state argues that Brownsville waived his right to insist upon the 60-day statutory requirements because he initially requested a continuance, which I said I did not request a continuance, and this is what the court wrote. The state knew, however, before it scheduled the trial for April 24th, that the defense was not available then and has specifically asked for the trial not to be scheduled that day. Nevertheless, the state noticed the trial for April 24th, which prompted Rumsfeld to request a continuance to the next available trial date. Pre-admitted whether Rumsfeld request for continuance acted to waive a trial for the first 60-day period. The evidence does not show that he waived the time of trial within the second 60-day period that had yet to begin. The state also argued that and the trial judge found that Rumsfeld waived his right to insist upon the statutory scheduling requirements by participating in a fruitless discussion to reschedule the trial. The record does not support this finding. Rather, the record shows that the Superior Court orally granted a motion to continue on April 21, after which nothing happened for more than a month. And it goes on with those dates. Skipping to the next paragraph, Your Honor, the Supreme Court of Georgia articulated the principle that forfeitures are not favored and should be enforced only when within both the letter and the spirit of the law. Before the state may forfeit a defendant's property, it must comply with the rules that afford the requisite procedural safeguard. But the burden is on the state, not the defendant, and this is what I stress. Thus, Rumsfeld is correct by asserting that it is not his duty to assist the state in depriving him of his property. The forfeiture statute requires the state to timely initiate the forfeiture action. Your Honor, what happens here, and I have three different ways, and each way I believe the claimant Mr. Williams wins. The first way is there's a stay in place. So I'm reporting on March 17, 2005, 25 of the court to the parties that we're going to have a trial on May 5. That stay is lifted, unbeknownst to me, but it's lifted on the first day of April 2025. That gives you that gives the state handles out all of April going into May, and May going into June. So June 2nd would be the 61st day. There was no trial. The state says that I waived it because my conflict. The case law says I did not. I then write to Your Honor the court 60 days, and now I'm up in New York, and there's these great orders. It was an exceptional experience in my life. There's these great orders there. And it's different than all these other cases. I'm not the lead. I'm part of this team. And there are times that, I just help people and I don't have any witnesses. So I want to accommodate. I know the 60-day period. So I felt the duty. So I wrote to Your Honor the court. And I write to Your Honor the court and I explicitly say that I'm available in May. Even if you go by the date of the stay as April 1, May 1, June 2nd. It's going to be the 61st day. I am alerting that I'm available in May. This is May 21. and I am available in June, let me know. Nothing happens. The state, and I am not picking on the state, I'm just waiting to the law. The state never advises this court, hey, we have a 60-day here, we need an order to continue for good cause. They're silent. The only one reaching out to court is me. I'm the only person. The state never initiates these communications. So to me, April 1 to June 2 happened, no trial. Yes, I had a conflict, but I had amended that conflict to say I can be here, and all that is in Exhibit D, my file. And I sent it to the prosecutor, and I sent it to your Honor Court via email. What happened, what does happen,
There she is
Your Honor Court states, you know, and it's my conflict, we're not going to go forward with me, and the court removes the May 5th date, as I said, on April 22. I am not saying that's for good cause, and I'm not saying that should erase the April 1 date. But even if it does, I believe that Mr. Williams still is the claimant who gets back the property, because now we start with the date of April 22, 2025. In the case of Whitaker, it's written by Judge Barnes. Can I have just 1 second?
Sure.
So, Rice, if the court, I did not cite this, I didn't do it on purpose, I just found.
That's fine. I don't have that case. So if you'll just give me the site, I'll pull it up on Lexis.
Okay. It is Rice 246 Georgia Appeal, 414, 541 Southeast 2D 58, 2000.
Sure.
So the reason I thought Rice was important for this exercise, Your Honor, and I'm Division 2, the prosecutor is reading along, Your Honor, that's on page bottom center, 3 or 4 on the copy of the report. And the Court of Appeals wrote, Division 2, although we have doubts about the propriety of granting an ex parte motion for a continuance in these circumstances, we need not address that issue because we find that the trial court erred by denying Rice's motions to dismiss the forfeiture complaints. Even assuming that the grant of the continuance was authorized initially, more than 60 days had elapsed from the date the continuance was granted until the trial court denied the motion for reconsideration on September 14, 1998. So what I learned from that case is we then go, which makes sense, the 60 days doesn't reset. In our example, April 1, 2025 to June 2, 2025, and then the state gets from June 2 to July or to August 2, 2025, because they would have additional more than 60 days from the date of the grant of continuance. So this really, that's what I thought. This case really helped that we do it from the date the continuance was granted. Well, the continuance that Your Honor was granted was on April 22, 2025. So if that's true, now we have April to May and May to June. So by June 23rd, 2025, more than 60 days have passed. That's June 23rd. The state did nothing in that period of time. I am announcing to the court I am available. The state is silent. It is their duty.
So here's what Brian Steele is arguing, and this is actually a very, very strong argument. If you guys remember, there were some items that were forfeited or taken by the state of Georgia from Young Thug. Things like cars, things like money, things like watches, things like material items. I have the original consent order, and I'll pull it up for you guys in a second. But here's where the state messed up. Okay, there was supposed to be 60 days in which a trial should have been, or a court date should have been scheduled. It was not. They were trying to blame Brian Steele because he was involved in another case. He was very proactive, saying, hey, I can make myself available. There are other people on Diddy's legal team, and I'm more than happy to show up for court if I need to. Now, the state never responded to that, and Judge Whitaker made a ruling on April 22nd that the state never responded to. That is what the core of Brian Steele's argument is. Let's go back in.
2025. That sets a schedule for August 18th. So we went, the state is now asking the court to ignore the fact that I did not move for continuance of Mr. Williams' appointment. I sent in what I'm required to do. I uploaded an amendment to it saying I can be ready. The state is silent. Mr. Williams goes from April 1 all the way till June 2 without a trial. It's not the court. That is the state of Georgia. Mr. Williams should win. Clemens should win. If you want to, not you, but if the court finds that, hey, there was good cause, this is what I'm finding, my April 22, 2025 order is in place. If within the first 60 days of lifting the stay, I'm not conceding that, but okay. Even if that, go under that scenario, then 60 days would end on June 23rd, 2025 without any word from the state that 60 days is going by without a hearing. And I'm making myself available. I put that in writing. I can be there. So I think the state is in. I just figure out. Now, let's just say, I'm not saying it's true, but let's just say the court finds that that stay is irrelevant, void, you didn't get notice, so we're not doing the stay. Mr. Williams still wins. Then what happened was, according to the records, the last person accused in the case related to the underlying, related to this case, the civil forfeiture case, the immigrant forfeiture case, was stayed by the former, the first judge on the case until the last person resolved their case. So that would be on June 10th. That's an automatic. Everyone's on notice. That's what the order says. The stay is over. 60 days starts right then. Well, 60 days starts from June 10th. We get the next day, June 11th, the real count. It's on the next day. So I counted this, and that would run on the 12th day of August. I think it's the 11th, but I'll say the 12th day of August of 2025. The court entered an order on June 24, 2025. So that's after Mr. Eppinger, we did PPM, GDR, resolved his case, but set it for outside the 60 days from June 11th. And the state is silent. And under Brownsville, I would be violating the law by alerting the court. But what I do, your court asks, are you available the weeks of July 21, 2025 or July 28, 2025? That's within the 60 days. I don't know about the state at the time. So I'm thinking, the state must have alerted somebody. That's fine. And I write back, yes. I'm available both weeks. And just let us know. The state says they need more than a day, they need a day and a half, and then it is scheduled out. There's no mention of anywhere in any of these orders for good cause shown. There's zero mention of it. The court would have to do it on its own. This honorable court would have to say that regardless of the fact that the state did not do its job on getting the court aware of the 60-day limit, and instead of putting it on claimant, which it can't do, then somehow the court says, the court's taking the position that it was for good cause. It's never written anywhere. That would be the first time anybody had said this is for good cause. I just gave all three scenarios that I could come up with. There are no other dates here. And in the state, let me just address this. I did respond when I saw the date on June 24, 2025 being today, August 18th. I mean, it's just my nature. I did respond to the fact that it was in the thank you so much. See you all soon. The state says that thank you so much somehow is me agreeing or waiving my 60 days on behalf of Mr. Whitaker. I don't have to object. And I'll give you that case as well. forfeiture statute requires the state to timely initiate a forfeiture action of seized property that's run to field. The state failed to schedule the trial date or request a continuance within the second 6-day period following the filing of the complaint. That's also what it's. But I have the exact case, Your Honor. 1 second, I'll get it. It's Goodwin, Good, WIN versus State, 321 Georgia Appeal, 548-739 South GD 814 2013. Would you like a copy?
No, I've read it. Thank you.
And in the footnote 7, the court wrote, there is no evidence that Goodwin consented to a hearing date outside of the 60-day deadline. Rejected, and then it cites a Griffin, GRIFFIN, 250 Georgia Appeal at 94-95 Division 1. Rejecting the state's argument that claimants waived their right to a speedy resolution of their property rights by failing to object when the hearing was scheduled on a date outside the mandatory 60-day period. You know, I would be doing Mr. Williams a disservice. Now, I did see it. I'm not trying to game in behind going by the date. And I felt bad. I told Mr. Root that. I told him, you know, I told him I can't think that you're out of time before I file that motion. I told him that. And I still think that. I will answer any of your questions, but otherwise, it's nothing to do with the facts of the case. It's just on.
Thank you, Mr. Steele.
I have nothing to add, Your Honor. We'll stick by our response. I want to belabor that point by just repeating our
Thank you. I do believe that it is correct that notification of a legal conflict does not equate to asking for a continuance. You know, I think counsel, we all feel like that people worked hard in good faith to try to find a hearing date, and we ended up with the hearing date of today. But the procedural rules and requirements of these forfeiture statutes are mandatory. The statutes are strictly construed against the state. There was no request at any time for a good cause finding to move the hearing outside of the windows that are statutorily required. I don't believe that acknowledging a hearing date operates as a waiver. The burden remains on the state the entirety of the time. And like I say, there was never any kind of request to the court to find a good cause based upon the hearing date being set for when it was. And I think that the court has no option under the case law and under the statutes but to grant this dismissal. So the dismissal is granted. And I don't know whether the state has any intention of appealing or not. And that's not a determination y'all have to make right now. But I would imagine if there is an appeal that the piece of property will be stayed until after that is sorted out. But at this point, that's the court's ruling.
Wow. And that concludes the hearing. So everybody, what does that mean? That means that Young Thug is getting all of his stuff back that was taken away from him. And just in case you have not seen that list, it contains the following: $149,000. Okay. That's in US currency, a 2022 Chevy Corvette, a 2022 Porsche 911, a 2022 Mercedes-Benz Maybach, another 2021 Mercedes-Benz. Wow, that's an AMG. Another AMG, another Jeep Grand Cherokee, a Durango, a Lamborghini, a Spider. There are about a few firearms. There's 1, 2, 3, 4, 5. Damn, you strapped 6, 7, 8, and a bunch of jewelry. Okay, so those are all of the things that were taken away from Young Thug, and because the state of Georgia made another mistake here by not following simple instructions, procedural instructions. That means Fonnie Willis and team have taken another big fat L. Let us know what you think about all this in the comment section below. Stay safe out there. See you in the next one. Bye.